Hi everyone, and welcome to July's Facebook Live. My name is Carrie Payne on behalf of Tara Lucke at the Art of Estate Planning, and thank you so much for joining us. I'm really excited to be back on board and sharing the knowledge with our wonderful followers. We're here today to talk about insolvent estates, and because of how broad this topic is, we are doing this as a two-part series. So this is what we're calling part one, and part two will be next month as usual. I want to thank our presenter today, Natalie Silvester, for joining us. Now, Natalie, if you don't know, is I think I need to read out a really long list of how great Natalie is because she's so fantastic. So I wanted to share a bit about Natalie so that you know how lucky we are to have her speak with us today. Natalie is a lawyer, obviously, through Legally Gifted Lawyers, her own law firm. She has a Master of Laws and lectures at the College of Law under their wills and estates topic. She's an accredited specialist and actually sits on the QLS committee for the Specialist Committee. She is also in the Succession Law Policy Committee for QLS and the Equity and Diversity Committee. And she's also on the Queensland STEP Board and on the Excellence Award Committee for STEP as well. So, Natalie, I don't know how you managed to fit it in and still come here to talk to us about insolvent estates, but we are so grateful for you being here. Thank you so much, and I think we're all ready to learn. Just a reminder that everybody, please feel free to comment your questions for Natalie, and we'll either discuss them at the end or we'll have relevant breaks throughout where it makes sense. If you have any questions that are a little bit more complex because this area is quite technical, we might suggest that you take them offline with Natalie or another practitioner that does practice in this area. So, Natalie, without further ado, the stage is yours.
Thanks, Kerry, for the introduction. Good afternoon, everyone, and thanks for coming to listen to me talk about insolvent estates. I've been involved in quite a few insolvent estates, so I think for today, the information I have for you today is drawn from a lot of the matters that I've been involved in where there have been insolvent estates. Today, I thought I'd break down the presentation into a few different parts. As part of the introduction, I'm going to talk about how insolvency affects deceased estates. It is probably not something that we come across in our everyday practice, but you know, the economy is changing, and I really think that we're going to see more and more instances of insolvency affecting or touching on deceased estates over the coming years. Insolvency can touch on the administration of deceased estates in a whole range of ways, and I'm going to walk through with you guys the how that happens. I'm also going to do a practical walkthrough of how to apply to the court to bankrupt an estate. I think that's an important thing to talk about when you're talking about insolvent estates, because if you're dealing with an insolvent estate, that is one of the ways to deal with that. So I'll talk about that. And when I was doing some research for the presentation, I went back through some of the live videos, and one of the things I couldn't see that had previously been discussed was rateability and how debts in relation to estates are dealt with, where in insolvent estates as well as insolvent estates. So I've got a little practical example to walk through in relation to how to rateably apply debts and that sort of thing, and how also abatement works as well. The other thing that I'm going to go through is a very brief overview of different parties or roles in an administration of the estate and how insolvency might touch in those roles as well. Alrighty, so as a way of introduction, I thought I'd go through some of the terms I'll use today. I'll probably refer to like LPR or legal personal representative, and that will refer to both executors and administrators of deceased estates. When I talk about trustee, I refer to a trustee of a trust and not a trustee in bankruptcy. I'll use the term bankruptcy trustee when I'm referring to a bankrupt trustees, and that will either be the official receiver or an appointed registered trustee. And an attorney is a reference to obviously someone appointed as an attorney under an enduring or a power of attorney. So insolvency can affect the administration of deceased estates in these ways. So the deceased may already be bankrupt at the date of death. The legal personal representative may discover the estate is insolvent during the administration of the deceased estate. A beneficiary may be bankrupt at the date of death or become bankrupt during administration, or the LPR might be bankrupt at the date of death or become bankrupt during administration. In addition, a person may become bankrupt when they're acting as trustee, whether of an estate trust or another type of trust, or if they have been appointed as a person's attorney and a power of attorney. So they're the sorts of roles and things that we will talk about today. So what's the difference between insolvency and bankruptcy? So insolvency refers to the position where someone is unable to pay their debts as and when they become due and payable, whereas bankruptcy refers to the position where an insolvent person has become bankrupt or a bankrupt person under the Bankruptcy Act. The Bankruptcy Act provides that a bankrupt means a person against whose estate a sequestration order has been made or who has become bankrupt by virtue of the presentation of a debtor's petition. So you can become bankrupt essentially by two ways, a creditor's petition or a debtor's petition. And that's the same for insolvent estates as well. But the key difference is that a debtor's petition is known as an administrator's petition. It's a petition made by the legal personal representative because, obviously the deceased person is deceased and can't do it themselves. So let's talk about the different types of petitions. So a creditor's petition, a creditor of an insolvent deceased estate or person can apply to the court by way of a creditor's petition to bankrupt the deceased estate. The court can make a sequestration order, which makes the insolvent estate bankrupt if it's satisfied that there's a debt of not less than $10,000 either to one or more than one creditor, and it's owing either at the date of death or incurred by the LPR, or the deceased person would be liable to pay if they had not died. The amount of the debt needs to exceed that of any secured property. The debt needs to be a liquidated sum due at law or in equity, or partly at law or partly in equity. And at the deceased date of death, the deceased was personally present or ordinarily resident in Australia, had a dwelling house or place of business in Australia, was carrying on business in Australia, or was a member of a firm or partnership carrying on business in Australia. A sealed copy of the petition was served on the LPR, although you can get an order to dispense with service in special circumstances. And at the time that the application, the creditor's petition is heard by the court, the debt remains owing at that time. For the LPR's petition, generally there's no amount, like $10,000 amount for the creditor's petition. There's no amount, there's no threshold. So an LPR can just apply if it believes that the estate cannot pay all of its debts. And if the court can make that sequestration order, which makes the insolvent estate a bankrupt estate, if it's satisfied that at the date of death, the deceased was, personally resident or ordinarily resident in Australia, had that dwelling house or place of business, etc. Same as creditor's petition. And so an LPR's petition is a lower threshold to get across the line versus a creditor's petition. The creditors have a few more boxes to tick in that respect, whereas the LPR, you could owe like $1,000 and make that application. The net value of the estate is in the negative. So knowing the date of bankruptcy can be important in some matters. The Bankruptcy Act provides for the date of bankruptcy to be deemed to have relation back to an earlier date than the date of petition. So specifically, if the deceased was unable to pay their debts on their date of death and they had committed any acts of bankruptcy in the period that is 6 months immediately preceding the date of death which they died, the relation back period is the time of the commission of the act or the first of those acts. So what that means is in that 6 month period before date of death, if the deceased person committed an act of bankruptcy, the date of bankruptcy is not date of death. It goes backwards into the time period of when the deceased person was alive and committed that very first act of bankruptcy. If the deceased was unable to pay their debts on their date of death, but they had committed no act or acts of bankruptcy in that 6 month period, then there is no relation back period and the date of bankruptcy is the date of death. And that can be important for the bankruptcy trustee's ability to claw in assets into the estate, which might have been disposed of in that possibly up to 6 month period before death. So that is something pretty important, I think, for us practitioners to have an understanding of if we're acting in an administration of an estate, or perhaps maybe we're acting for a creditor and we become aware that there were assets disposed of before the death, then we can work out if there was an act of bankruptcy in that period of time and use that relation back period. So let's talk about the effect of bankruptcy. Upon bankruptcy, the property of the bankrupt vests in the bankruptcy trustee, and any after acquired property of the bankrupt vests in the bankruptcy trustee as soon as it is acquired or devolves on the bankrupt. Property has a pretty broad definition in the Bankruptcy Act. You'll see on the PowerPoint, I've got a slide there. It includes pretty much everything, including present and future vested or contingent interests. And I'll talk about that a little bit later on and how that might capture a life interests and stuff. So it covers very broad, and it also includes if the deceased had an interest in another deceased estate. So when you're acting for an LPR, most of you would probably already know this. They have a whole heap of duties and liabilities in the administration of the estate. Things like organising the funeral, approving the will, collecting assets, paying debts, and things like that. Sorry, just give me one sec. I've been sick over the last 2 weeks.
I'll let you catch up there, Natalie. I appreciate everyone's been very unwell over the last few weeks, and especially when you've got kids, they tend to bring home everything that you can imagine. So,
and I just want to mute myself while I'm coughing.
That's totally fair. That's totally fair. So I'll let you catch up again now.
Awesome, thank you. So when we're talking about those liabilities, that also, the LPR can incur debts during the administration of the estate. That includes things like the funeral expenses, legal costs. And the thing to advise LPRs is that they are personally liable for those costs or those debts that they're incurring. I think sometimes it can be a common misconception, particularly with lawyers who aren't practicing in this area a lot, that the estate pays all of the legal costs. But the client of yours is the LPR, not the estate. And so the LPR is personally liable for their legal costs. If the LPR has acted reasonably in incurring the debts, and the debts are of a reasonable amount, and the LPR has acted reasonably in the administration of the estate, then the LPR is generally entitled to an indemnity of the estate from the estate funds of the debts that they have incurred. But that's the position for solvent estates. Insolvency estate, the indemnity from the estate for debts incurred by the LPR depends on the type of debt incurred, as it'll need to be paid in order of its priority with other debts. So when acting for an LPR who is aware of a person's estate is or is likely to be insolvent, the LPR should be put on notice to minimise funeral testamentary administration expenses. Otherwise, they could find themselves liable for part or all of the expenses incurred for them and be out of pocket for that. Sometimes, due to the debts of the estate and the limited assets of the estate, the LPR may be out of pocket for those expenses they incur. And I've had clients in that position before where they've had to pay, they've actually had to personally wear part of funeral costs and legal costs just due to the priority. The LPR is also personally liable to the bankruptcy trustee if they transfer property of the deceased person after service of a creditor's petition, or if the creditor's petition was served on the deceased who later died after the LPR has knowledge of the presentation of that petition, and after presentation of a petition by the LPR. And I think that's pretty reasonable process. So it's after the service and not after the hearing. So if in any of those situations the LPR distributes or gives away or pays other debts in the incorrect priority, then the LPR can find themselves personally liable to the bankruptcy trustee to replenish those funds. So I wanted to just have a quick chat with you guys about priority of debts in deceased estates, and firstly, solvent estates. So priority of payment of debts is dealt with in sections 55 to 61 of the Succession Act. Now, I'm talking about Queensland here. I'm sure there's probably similar equivalents in other jurisdictions. And those sections set out, is it a solvent estate? This is how it's dealt with. If it's an insolvent estate, this is how it's dealt with. For solvent estates, section 51(1) of the Succession Act provides the order, and it's dealt with by class number. So class 1 assets are property specifically appropriated, devised or bequeathed for the payment or charge of debts. And so that generally happens when the testator has left a will, and in the will they might put in there something along the lines of, I want this particular asset or this particular bank account or something like that used towards the payment of my debts. And if so, then that asset is considered a class 1 asset. Class 2 assets are the residuary estate. So any assets that fall within the residuary estate are considered a class 2 asset. Class 3 assets are property that's specifically devised or bequeathed to another person, like in the will. So that includes specific gifts of property. And class 4 assets are, and I can never pronounce this properly, but donatus mortis causa, which is essentially, that has 3 elements. The donor gifted the property in contemplation of their death in the near future. The donor delivered the essential indicator of title to the asset to the donee with the intention to part ownership with the asset, and the gift is conditional on the donor's death. I don't think I've actually talked this much for like 2 weeks, so I'm just constantly coughing. I feel like I'm really sicker than I actually am.
No, No. I'll give you a bit of a break there, Natalie. I know that you've been talking a lot, and again, it's especially difficult when you're not feeling 100% or you're recovering from something. And the cough that is going around with flus at the moment is terrible.
What I might do is I might jump to like the practical scenario and just have everyone read through that, save me talking about it.
Yeah. And I think just to make it clear that it's obviously very different when you're dealing with a solvent estate versus an insolvent estate, which we're going to be talking about, like touching on the difference between the two to some extent. So.
Yeah, and this, the rateability exercise is in relation to a solvent estate where there's an abatement, but you can utilise the same principles and formulas and stuff to work out like insolvency and where things go as well.
And just while I give you a bit of a break there, and we'll talk through this example in a moment, but if you're unaware whether the estate is insolvent until like the debts come at you, is it best to treat it as insolvent until you know, or is it best to treat it as solvent until you know what the debts are?
I would treat it as probably more insolvent. The biggest things is not to distribute any assets out of the estate, because it then goes back to the LPR being personally liable. And to try and minimise those funeral and legal costs as much as possible until you know. Sometimes you might not have a choice to incur some expense. But if we'll talk about, like I do talk about like the different priorities between the Succession Act and the Bankruptcy Act about that in a bit later on. But yeah, an LPR can find themselves out of pocket. And so that's a very real discussion you need to have with your client. And I've had some clients who just renounce because they don't want to incur any of that personal liability.
Yeah, excellent. All right, thanks for that. I'll let you go on with the examples.
So hopefully everyone's read through the Christine's estate. So how is the remaining 10,000 split? The first thing we need to do is work out what class those gifts fall into. The specific gifts would be a class 3, and then the residue would be class 2. So that's relatively easy to work out generally. So working through the classes, there is no class 1 gifts, just work on that. There's no specific clause in the will that deals with that. Class 2, there is $30,000 of specific gifts. So putting liabilities to one side, the residuary estate is $20,000, $10,000 to each of Clara and Kyle. So that full amount of $20,000 would need to be used to discharge the debts in part, which would mean the residuary estate abates entirely and there would be no distributions to Clara and Kyle. There's just nothing left in the residuary estate. You then have $20,000 of liability left to be paid. And it says here on my slide 40,000, that's a typo, that should be 30,000 in specific gifts. So then what you need to work out is how the 20,000 is paid by each of those specific, the beneficiaries of those specific gifts. And that's where you ratably calculate them according to their value. So here is a table that has the formula to do that. You can see in the first column, you have the beneficiary and the value of their gift. And the formula is worked to get the percentage. The formula is worked out of their value of the gift versus the divided by the total amount of the gift. So for Bob, he's got a specific gift of 15,000 with a total of 30. So his percentage contribution to the debt is 50%. There's 20,000 left over, so 50% of that is 10,000. And so ultimately his entitlement will be 5,000, which is the $10,000 contribution to the debt from the 15,000 original debt gift equals 5,000. And then that goes down, similar formula for Harry and also Madison. So before we go any further, does anyone have any questions about how to rateably apply insolvent estates? Just thought I'd throw that out there now while we're at that table.
While we're there, I haven't got anyone coming through with those sorts of questions yet, Natalie. I suppose
Awesome.
for me, I just wanted to know, in your practical experience, is this something that we should be like, if we were a lawyer acting for a client, is this something that we should be doing the numbers on, or should we be engaging with an accountant to do the numbers on? How do we, as a practitioner, how do we facilitate that process?
I've always done them myself. I've not ever engaged an accountant to do this calculation. I think it all forms part of your estate accounting. And should be done within the estate accounting, which I have always done as a succession lawyer. They can get quite hairy in respect of how complex they can get, particularly if you've got like multiple classes. And I have had a situation before very similar to this where residuary estate abated fully, and then we had to rateably apply the remaining debts against the specific gifts out to the beneficiaries. And that can be a really, I think, difficult conversation to have with those residuary beneficiaries, where you're telling them, well, there's actually, you're not getting anything. You're not getting anything at all. Yeah, I think practitioners need to probably know how to do this. It's not, again, it's like one of those things that you probably don't see in everyday practice, but if it comes across your desk, it can sometimes be good to go, oh, I sat in that Facebook Live and Natalie had the formula of what I needed to do and work it back to that. When I was going through this, I couldn't see where it had been dealt with before. So it sort of rolls into like dealing with debts of the estate and that sort of thing, which is why I thought I'd cover it.
Yeah, I've got a couple of questions that have come through, Natalie. First of all, I'm allergic to maths is probably the best way of explaining it. So I would probably lean in and get someone who does do as a cease estate work, who is an accountant as well, to help me make sure that I've got the number crunching right. Just because I think that, me personally, it's a red flag waiting to happen by me trying to tackle those on my own. I've got a couple of questions here. So Timothy's saying, it seems fair to say that all the funeral, estate and testamentary expenses need to be proportional and may be disallowed if excessive. Does the higher standard come from the fact of insolvency under the state law or the approach from the federal court?
So it's easier and better from a liability perspective for the executor to try and I talk about this a bit later on, but to administer an insolvent estate under the Succession Act versus the Bankruptcy Act. The Bankruptcy Act, I think the Succession Act has maybe like 4 or so different levels of priority, whereas the Bankruptcy Act has 19, but that's something I'll talk about a bit later.
Okay, so the higher standard itself is probably coming from federal then, or?
Yeah.
Okay, all right. Denise is asking, what about the tax considerations impact to beneficiaries? So Denise, maybe I might need some clarification there, but do you mean like the tax effect for the estate in general, like for residuary, or maybe Natalie, you might understand that question a bit better than me, given your knowledge?
Well, a general tax debt is considered just, in my view, a normal asset a normal liability of the estate. I don't believe it's got a priority. It would be considered essentially an unsecured creditor. A lot of the insolvent estates that I have dealt with, the ATO has actually been a creditor. And so they are an unsecured creditor, and they don't have a higher priority over other creditors. I suppose it could possibly get a little bit tricky if, in this situation, there's perhaps maybe these shares had to be sold to obviously pay part of the debt, and there was capital gains tax liability, But I think at the end of the day, you'd probably get specialist advice at that point. It's probably a bit over more high level than this presentation, as to whether that tax debt would all be a residuary side of things or go towards the specific gifts. I think for being practical, it would just need to be a particular just a general liability, because trying to work out what part of a tax debt was for this particular capital gains might be a bit difficult. But I'm not an accountant, and in the insolvent estates that I've dealt with, I've not actually come across that particular issue.
Yeah, I've just had some clarification from Denise too. So I think it's more about, so if you have to sell a specific gift to, what happens to the tax debt that can occur as a result of that?
Yeah, so that's a tax debt incurred by the LPR, but it's like a necessary. So then you talk about, so if there was a tax bill before date of death versus a tax bill after date of death, there's different order of priority for that as well. So that's all set out in the Bankruptcy Act and also the Succession Act. So the tax debt incurred by the LPR would be considered, one of those like administration expenses, and would have a priority over pre-death tax debt. And I've had that situation before as well, where there was a post-death versus pre-death, and we had some assets which were like life insurance and stuff, which couldn't be used to pay the pre-death liabilities, but could be paid for administration expenses. So we're able to use, I don't know if it was life insurance or maybe super, we were able to use that money to pay for the tax, but not pay for the pre-death tax.
Yeah.
Hopefully that makes sense.
I think when we talk about what makes sense in this context is it is so complex that until you have all the exact scenarios, it's not easy to just talk off the cuff. But from what you're saying is that, if there is some sort of thing like CGT that occurs on selling an asset, that is treated differently than pre-tax debt, and it's seen more as administration cost, and therefore would be higher priority than other debts.
Yeah, and the CGT bill that's raised post-death from the estate administration side of things would have a higher priority over, say, for example, if the deceased had sold a CGT asset in their lifetime and hadn't paid their debt there. Yeah. So there's the different priorities from that as well.
Yeah, so pre and post-death have totally different treatment, and obviously post-death, if it's been a necessary expense as a part of administering the estate, that takes priority or is higher in the priority chain.
Yeah.
Okay. Thank you for that. I think that's all the questions we have on that part.
Excellent. So let's talk about, the priorities between the Succession Act and the Bankruptcy Act. Oops, I keep doing that, sorry. So in Queensland, Section 57 sets out the priorities. So the first priority is the payment of funeral, testamentary and administration expenses. And then it goes down there's secured assets and then unsecured debts and stuff. The Bankruptcy Act has 19 different priorities. So there's a whole heap of stuff that the Bankruptcy Act, and also there's bankruptcy regulations as well. And you've got to read the two in conjunction to one another to figure out what the actual priorities are. And Carrie, I actually have a table that sets all of this stuff out. So what I might do is I might send that to you after the presentation, and perhaps maybe you could upload it or distribute it to those who might want to know what those priorities are, because it does take actually a lot of time to read the two acts together and to figure out what the priorities are, but there is 19. The biggest things to note, I think, is that the priority or number for funeral expenses is 13 out of 19, so it's not even up in the top 5. The bankruptcy trustees' fees for administering the bankrupt estate are priority number 8. So the LPR who incurs a funeral expense gets paid after the bankruptcy trustee gets paid. And the costs of the creditor or the LPR in making the bankruptcy application to the court is number 7 in priority. So it's a higher priority versus the bankruptcy trustee and also the funeral. So when you're talking about who's incurring funeral costs and that sort of stuff, you can't always just say, oh, well, that's always paid from the estate, because it's pretty low in priority if it's a bankrupt estate or it becomes bankrupt. There can be some benefits, though, to bankrupting an estate. And for an LPR, it could be not having to liaise with a really aggressive or difficult creditor. I've had an instance where that's happened before. The creditor was really quite difficult. And so it was just easier to tip the estate into bankruptcy. Not being liable for incurring any further testamentary administration costs, including legal costs, where your client might not be able to be indemnified from the estate assets. And for creditors, it's the ability to be able to claw back in assets that might have been transferred by the deceased, perhaps maybe even for less than market value, in that relation back period and that possibly 6 months period, which could then enlarge the pool of assets to be paid out to creditors. So there's some pros and the cons, obviously. You know, if your executor has incurred in a lot of costs for funeral and that sort of thing, they might be out of pocket, but there's also some benefits for bankrupting an estate. So we're going to shift the conversation now into what it looks like at particular moments in time when you discover bankruptcy. So the first one is the deceased is already bankrupt at date of death. If a person is bankrupt when they die and they've not been discharged from that bankruptcy, the bankrupt's assets that would ordinarily vested in their bankruptcy trustee, they would have already, from the date of when they became bankrupt, all of those assets have vested in the bankruptcy trustee. So there's not really a lot sometimes for the LPR to do. But it could be that there's some assets that form part of the estate after the bankrupt dies. That could be things like superannuation, life insurance. So there might be some assets that the LPR might need to deal with to call in those assets. And those assets are generally protected from bankruptcy if they're called in after the date of bankruptcy. And things like funeral and that sort of thing. One thing that I didn't know about until a few years ago was that in relation to funeral expenses, someone dies in Queensland and has no next of kin, then the Department of Justice and Attorney General is authorised to make funeral arrangements for that person through the coroner's court. So there's a scheme about that, where if it is a completely bankrupt estate, it's got no money, like the person literally had nothing, then the government essentially can fund the funeral through it's called the Coroner's Court of Queensland Funeral Assistance Scheme. But it's pretty strict, and they also do have the ability to try and recoup those funds from a spouse, a parent, or a child of a deceased person who applies for that assistance. So that's just something to be mindful of, that if there is a completely bankrupt, or insolvent estate, perhaps maybe your client isn't a relative who's come to you, there's no way to pay even a funeral expense, there's the scheme there that could look at paying for it. If bankruptcy proceedings were commenced prior to the bankrupt dying, but an order hadn't been made at the date of death, then the bankruptcy proceedings would just ordinarily continue on. And that's dealt with in Section 63 of the Bankruptcy Act, where the court can determine those petitions as if they're alive. Next we have
can I just jump in there, Natalie, just to give you a bit of a break? Number one, Tara's commented, which I totally agree, that the idea of not having enough money to pay for a funeral is just heartbreaking. I'm going to bounce that into another question. What is seen as being reasonable for how much to expend on a funeral, in your experience?
I think it depends. If you're literally looking at someone who has nothing or very, very, very limited assets, I would be doing literally like an unattended cremation. And I think they're about $1,300 or $1,500. So that's your bare minimum expense, is an unattended cremation. And that doesn't include that doesn't include like funeral services or anything like that. Like if you really look at the LPR's duties, is not to organise the funeral of the deceased, it's to dispose of the body of the deceased. And so realistically, you've got to do that in the most, practical way. And I think it's common practice for funeral services and stuff to occur, but there's significant expense in funeral services. And so if you're dealing with a really limited estate, I'd be minimising those costs as much as possible.
Yeah, interesting.
And also things like wake expenses as well. Like generally, wake expenses, sort of go hand in hand with a funeral service, in that, a wake is not necessarily, it's not necessary to dispose of the body. And so if you're incurring expenses for the wake, I'd be pretty careful about whether you're going to be able to recoup that from the estate.
That's interesting. We spent about $8,000 on the bar at my father's funeral recently, so I don't know if we'd ever get any of that back in that context. So,
but you know what? Like if you and you're, if the people who incurred that expense are the beneficiaries, then it's a solvent estate. It's not going to be a problem, right?
Yeah, that's right.
So we're talking about insolvent estates, or perhaps maybe the person incurring that debt is not a beneficiary of the estate. Maybe the beneficiaries of the estate are minor beneficiaries who can't consent to the payment of that expense coming from the estate. So, when you go back and you strip it back as to what the LPR's duties are, it's to dispose of the deceased body. And things like funeral services and wakes and stuff are the extra, almost like the extra. It's the extra. It's not the actual bare minimum. So I think
it's such a cold way to think about it, because
it is. It really is.
Funerals are a really cathartic process for the people that are left behind.
Yeah. And I think as well, if you act reasonably, if you're incurring like a $3,000 to $5,000 funeral and maybe the estate's solvent, there's probably not going to be questions asked. But if you're doing like a $20,000 funeral and I want like a pink glitter coffin, like that's just what I want. But if I have an insolvent estate or something, or no one can consent to that, then my LPR better be careful. So I just think it really just depends on the circumstances. If there's like a lot of money there's beneficiaries who are of age and capacity and stuff to consent to things, and they're possibly even the ones incurring the expense, it's probably less of a big deal. And versus, perhaps maybe executors without an actual interest in receiving a distribution from the estate, or there's minor beneficiaries or beneficiaries who don't have capacity.
I think that's something we've really got to think about from a planning aspect as well too, isn't it, when we're thinking about who we appoint in those roles and the decisions they're going to have to make. So I've just got another question here, and sorry, Denise has also just said she got a quote for a minimal cremation only, and that was still close to $5,000. So
I know when my dad died, he didn't want a funeral service, so we did an unattended cremation because that's what he wanted. And it was about $1,300. But in fairness, that was back in 2016. So I imagine, with everything increasing, that the costs of that have increased. But they're just figures that, I've been involved in before. But it's been a few years.
Yeah. I've got a question here too from Tim. In relation to, the date of bankruptcy being important, in terms of the priority, I think he's just confirming that that's why it's so important to know which side it falls on.
Correct.
Yeah.
And also, if you're acting for a creditor and there's assets that you can claw in pre-death, like if you think about, for instance, this is really important. So, normally things like superannuation and life insurance can't be used to pay debts. However, if life insurance and super are paid after bankruptcy, they're no longer protected. And so if a bankrupt person draws down their super, 2 weeks before they die, then the period of bankruptcy could be very important, perhaps maybe for that or for life insurance after death. I've been involved in one matter where the insurer paid the amount to the LPR instead of to minor children, and it was an insolvent estate. And so if it went into bankruptcy, the life insurance could be used to pay creditors, whereas if it didn't get tipped into bankruptcy under the Bankruptcy Act, then it wasn't able to be used to be paid for creditors. So there can be sometimes strategies in timing of payment of life insurance, whether it's pre or post a bankruptcy application. It might be strategically that you possibly look at bankrupting an estate sooner rather than later if there's going to be life insurance paid into the estate at a later date.
But hold on, just clarifying that. So it's better to declare bankruptcy before life insurance is paid in?
Absolutely, yeah.
Okay, very interesting.
All
right. I'll let you kick off again. Sorry, Natalie.
I think we're actually going to we finish up at 1, don't we? We're probably going to run out of time because we've sort of gone off on a few little tangents, which has been, I think, really quite beneficial. But some strategies you can use for an insolvent estate instead of bankrupting it. You can write to the creditors to ask them to write off the debts. I've used that in a lot of cases. And if you've got like a lot of unsecured credit card debt as the major debt, and it's a pretty low value estate, then a lot of credit card companies will just write off the debt, and which will allow some money to go to the beneficiaries. You can enter into a deed with creditors to do a cents and dollar payment. So provided all creditors consent, you can try and do a cents and a dollar, and it's something similar that a bankruptcy trustee will do, but without incurring the costs of like your bankruptcy petition and the bankruptcy trustees. So generally, if creditors are amenable to that process, they'll get a better deal out of it. Or you can apply to the Supreme Court for directions to administer an insolvent estate under the Succession Act. But if a creditor objects to that, then you're going to be forced into bankruptcy, and you might have an issue as to cost. There can be some sort of like strategic reasons why you would do that. Again, if you look back at that, maybe life insurance that is being paid to an estate, which could be protected if it's administered under the Succession Act versus the Bankruptcy Act. I think we've mostly covered all of this sort of stuff. So I really just wanted to run through with you like a bankruptcy application and the steps. When I've done them in the past, the process has been a bit convoluted. I think also because succession practitioners are not used to I think dealing in the federal court. I know certainly I'm not. So the first time I had to appear in the federal court was very different to say appearing in the Supreme Court. So the biggest I think advice I can give practitioners who have to do a bankruptcy application is you don't want to necessarily incur the costs of a barrister because you want to try and minimise costs as much as possible. So you want to try and do it as lean as possible. The federal court has a cost practice note, and it provides a step-by-step guide to practitioners for claiming costs. So make sure you have a look at their cost guides. The other thing as well is when you go to a final hearing for a bankruptcy application is that you have to essentially have almost like a bill of cost given to the judge to go through, and then the judge decides how much cost you're going to get. So just because your bill of cost says it's cost you like $6,000 to get to that hearing doesn't mean you're actually going to recoup your $6,000. So they're just some tricks I think I learned along the way when I've been doing bankruptcy applications in the federal court. So from a filing perspective, like how do you get started if, you've tried maybe the informal routes and you've got a difficult creditor who just won't agree to say cents in the dollar, or you've got a client who might not want to run the risk of a Supreme Court application and you are having to bankrupt your estate. Then it's Federal Court Form B15, which is the Legal Personal Representative's petition. You need an affidavit proving the matters in the petition, which is essentially that there's debts and stuff in relation to the estate. And you need to also file an affidavit exhibiting a Form 4 Statement of Affairs. And that can take you ages to fill out, particularly if the estate has been ongoing for a while, because you have to deal with essentially what's happened through the estate administration. So for a creditor's petition, it's a Form B14 creditor's petition application. Once you file, you have to send the sealed petition to the official receiver. You have 2 business days to do that. There's very strict timeframes under the Bankruptcy Act to do these steps, and they're like strict liability offences where you can be liable for penalties if you haven't fulfilled these obligations. So again, it's important to be aware of these timeframes before you go down the process to make sure you meet them on the other end. So you've got 2 business days to give that petition to the official receiver. You then have to serve creditors 5 days before hearing. And then you go to the hearing, you have to have prepared that bill of costs. You have to file an affidavit confirming service. And you also file an affidavit confirming that the estate hasn't been made bankrupt before. So you've got to do one of those NPII searches on like the bankruptcy list. And then you go along to your hearing. You make your relevant submissions and stuff. The judge makes the order. They'll also let you know how much costs you're going to, or the creditor or the LPR will be awarded. And then after that hearing, you've got 2 days, business days again, to provide the order, the bankruptcy order to that official receiver. So there's some other timeframes as well within that. So if it's a creditor's application, then an LPR has 28 days to file the statement of affairs because the creditor won't have a statement of affairs. So there's that time frame as well to be made aware of. And for a LPR, you've got to file that statement of affairs with an affidavit at the original filing, so you can't do it later on. The court will actually reject your application or your petition if you haven't done that Form 4 Statement of Affairs. And the other thing about that Form 4 Statement of Affairs, and it doesn't say this anywhere, is that it has to be exhibited to the affidavit signed by the LPR. If it's not exhibited to the affidavit, the court will actually reject your application and make you do it. I was in that position because their information didn't actually say it had to be exhibited to an affidavit.
I'll let you have a breath there, Natalie. That just sounds like typical law, like missing one thing. Doesn't go by the vibe at all. The small stuff does matter.
The other thing to know as well is that to even file a petition in the federal court, you can't just go up to the registry. It has to be done all through like the Commonwealth Law filing portal. There's a special portal. So if you go to the federal court website, they have a portal that practitioners will need to sign up for, and you have to pay the filing fee through the portal as well. So you need to have set up access to the portal. I don't know what the process is for that, because the firm that I worked for was quite a large firm, and we had a litigation and insolvency division. So I had our insolvency lawyers file it for me. But if you're like a sole practitioner or a small firm or something who hasn't filed anything in the federal court before, then you're going to have to get set up with the ability to file. So that's also something to note. So let's just quickly talk about, do we have time, or are we running out of time?
I think you can just speak, and if you get to the point where it's too much, we can certainly cut it off.
Yep. So the other thing I wanted to chat about is the different roles of people in an estate administration, and what happens if they are bankrupt. So one is executors. If you've got a bankrupt executor, what happens? There's no limitation in the law that if you're an executor and you are either bankrupt or become bankrupt, you're actually excluded. You're not excluded from continuing to act as an executor. So you can continue acting in that role. There's a decision there where a court found that the bankruptcy wouldn't hinder the executor from administering the estate, and allowed the bankrupt executor to continue. If the bankruptcy would hinder the administration of the estate for whatever reason, then a court is likely to find that the executor probably shouldn't continue and might need to be removed.
Natalie, is that subject to any terms in the actual governing document itself? So that if the will says if they're bankrupt they can't act, is that?
Yeah, well, obviously it's contrary to anything else in the will. So if something's in the will that says if my executor is or becomes bankrupt, then they're excluded or to be removed, or words to that effect, then obviously you would follow what the will says. But under like the Succession Act, there are no limitations. In Queensland, the UCPR forms for affidavit in support of things like your probate application and stuff. Your executor administrators need to swear to standing as a fit and proper person to realise and administer the estate. I suppose there's a question of whether a bankrupt executor is a fit and proper person to realise and administer the estate. There is literally nothing in any of the acts or the UCPR rules about what that means. And so normally what I do when I'm advising clients about what that means is, could anyone possibly object to you being an executor or administrator? And if so, then we probably need to chat about that and, the possible consequences, which is really just if someone does object, there's a cost risk, I suppose, for someone making your application and perhaps maybe not being successful and incurring costs. Going back to the position that an LPR is personally liable for their own costs unless they get an indemnity from the estate. So they're not specifically excluded, obviously, unless there's a contrary intention in the will. Bankrupt beneficiaries, the LPR's duty is to distribute to the correct beneficiary. A bankrupt beneficiary's entitlements vest in the bankruptcy trustee. So that's really, really important. A failure to pay the bankruptcy trustee, bankrupt beneficiary's entitlements, you could be held in contempt of court or your client, LPR. The bankruptcy trustee could enforce possession or even make the LPR personally liable. this is why I think Lexon always suggests in their checklist that you should ascertain the bankruptcy status of beneficiaries before distribution. I know there can be sometimes a bit of an argument over, okay, is that statutory declaration that everyone does is enough, or should you be doing bankruptcy searches? I think the general position is that a statutory declaration should be sufficient. But if your client is on notice that the beneficiary may be bankrupt, or has their suspicions, or perhaps maybe the beneficiary might be a little bit on the sus or dodgy side, I'd probably be erring on the side of caution and doing a bankruptcy search. The way that the bankruptcy trustees do this is that the beneficiary's interest in the estate is a chosen action, and that chosen action passes to the bankruptcy trustee. Oh, sorry, I keep doing that. So if during the administration your beneficiary is discharged from bankruptcy, their entitlements don't revest in the beneficiary. So, for instance, if at date of death the beneficiary is bankrupt, then, a year later you're still doing the administration, haven't distributed everything, but they've been discharged from bankruptcy, you can't then just give that beneficiary their entitlements. You still have to go back to that bankruptcy trustee, because on the death, or the 30 days from death, that's when that vested and contingent interest in the estate vested in the bankruptcy trustee of that beneficiary. And so you have to go back to the bankruptcy trustee. So, and that's why that statutory declaration is like, have you ever, in the past been a bankrupt, or are you currently bankrupt? Because if they have in the past and it was after the death, then you need to go back to the bankruptcy trustee.
That's so important too, Natalie, when we think about from a planning perspective. It's not just whether they are at the moment or at the time that you draft your will. You've got to assume that they might have been, or that they might be in the future. And it's one of the big reasons why we really advocate for testamentary trusts, is because provided they're structured appropriately, then they give the beneficiaries, or they give the estate funds protection from those sorts of events.
Yeah, absolutely. Absolutely. And I agree with that. I've had one executor client who had there was a bankrupt beneficiary, and the bankrupt beneficiary asked the executor to hold on to their funds until they were discharged from beneficiary, like a year or so later. But it is an offence under the Bankruptcy Act to conceal property of a bankrupt from bankruptcy trustee, and you can go to jail for 5 years. So I told that executor, no, don't do that. Let's contact that bankruptcy trustee. This case of Meg Elliott and public trustee, I mention it just for anyone who wants to do some extra research. In that matter, the bankrupt tried to argue that bankruptcy was a disability, and that their share should be held on trust by the executor due to their disability. And so the question raised was whether the beneficiary was under a legal disability as a result of the bankruptcy, and the court found that the bankrupt beneficiary was not under a legal disability. And so I thought that was a pretty novel argument to try and avoid the money going to the bankruptcy trustee. So I think this is pretty important as well, and possibly even from a planning perspective, but even also the estate administration side of things, like how are these dealt with when a beneficiary is bankrupt. So if a beneficiary is left with an entitlement, that's a right to reside or a life interest, it can create complications for the estate. So I'm sure we all know that a right to reside is literally just that, the ability to live in the property. You can't earn income from it. And if you vacate, your right to live there is extinguished. It would be very difficult for a bankruptcy trustee to force the bankrupt beneficiary from their home in an attempt to collect the asset, as the asset provides no other beneficiary, so no other benefit to the beneficiary other than accommodation. However, a bankruptcy trustee could consider the occupation of the property pursuant to a right to reside as income. And whilst the legislation doesn't specifically mention rights of residence as being considered income, there's a whole heap of commentary surrounding the interpretation of income of a bankrupt, and that suggests that a right to reside may be considered income. And if it were considered income, then the value of the right to reside might push the bankrupt over the income thresholds, which require contribution by the bankrupt to the bankruptcy trustee to pay their debt. So I think if their income's over, I think it's like there's a threshold of like 80,000 or something like that. The bankrupt has to pay money, like it's like 50 cents in the dollar of their income to the bankruptcy trustee to go towards their debts.
That's huge, like, because often with your planning, like, you know, we say if you are dealing with a bankrupt beneficiary that you want to give them the ability to live in a property, but you don't want them to own it. I mean, to hear that, I was so not aware of that. That's massive to think about.
Don't quote me on those figures, but last I looked, it was about that, I think.
Yeah, no, so, I'm not definitely not the figures, but
it is substantial, yeah, and it always changes. It's like increased every year and that sort of thing. So, and so the biggest thing to that is if, you know, this beneficiary has been living in this property with under a right to reside, and the bankruptcy trustee is like, well, no, that should be considered income, and they've been there for a few years, and they haven't been making regular contributions, then that's just going to further put that bankrupt beneficiary into like a really, really bad position. And if the bankrupt beneficiary is receiving wages, then the bankruptcy trustee can go and garnish those wages as well to pay the money that they haven't paid. So there can be some big consequences there from a right to reside. And then on the flip side, you've got your life interests, and this can create huge problems for the estate where the beneficiary of that life interest is bankrupt. And that's because a life interest satisfies the definition of property under the Bankruptcy Act. And so the bankrupt beneficiary's life interest actually vests in the bankruptcy trustee, and any income earned on the assets of the life interest is considered income of that bankrupt beneficiary. And so from a practical level, the bankruptcy trustee could evict, if the bankrupt beneficiary was living in a property, could evict the beneficiary from the property. They could lease the property and collect the rent, or they could sell the property or have them arrange, you know, get orders to have the property sold and collect the income off the money invested. Or sometimes what could happen is that the bankruptcy trustee could negotiate with the remaindermen of the life interest for a lump sum payment in lieu of the life interest. And that can be up to a maximum period of like 20 years of that person living there. It's like the way they calculate the life interest amount. So having a life interest to a bankrupt beneficiary has huge consequences, not only for the bankrupt beneficiary in that they, you know, possibly won't be able to live there or receive an income from it, but also that from the remainderman's perspective, that it's considered property. And the bankruptcy trustee could negotiate, you know, try to negotiate with them to have the property sold, and it all divided up at that point in time.
Yeah. I'm conscious of the time. Natalie, is there anything else that you quickly wanted to go over with the presentation, or?
No. Like the remaining things that I cover is bankruptcy trustees. Again, review the deed, and there's no like exclusions. Similar with bankrupt appointors and principals, and bankrupt attorneys in Queensland. They can't act for financial matters. They can act for personal and health matters. So other than that,
I think just to clarify, you are going to provide the slides. I think we talked about this before we started.
Yeah. I think what I'll do is I'll provide the slides, and I'll provide. I have a little bit of material. I can provide the Bankruptcy Act priorities, and I could probably provide the steps to bankrupt the estate. That probably would be, I've got the creditors version versus the administrator's version. So I could probably provide all of those if people are interested in them. And
we'll make those available. So thank you, Natalie, for offering those. We'll make those available for everybody through the platform. So if you've got any questions that are sort of specific, please reach out to Natalie. She's very clearly a very busy woman, and to the extent that she thinks it's something she can't help out with, she's obviously connected enough to people to know where to recommend you go to. Thank you so much, Natalie, for your time today. I really do appreciate you sharing your knowledge with us, and given there is so much knowledge that you've got, and on an extremely complex and I imagine quite emotional topic when you're dealing with deceased estates, plus the stress of that as well. So it's always in the back of our mind as practitioners. There's obviously legal requirements, but we are dealing with humans and the complexities that encompasses as well. So thank you again so much for your presentation, and as I said, feel free to reach out to Natalie if you have any questions. She's got her contact details there.
Lovely. Thanks for having me.
Thanks, Natalie. Take care.
Bye.